Sir, hold on. I am a little concerned because both of your instances mention service of an injunction against harassment, and that is a lawful basis. That's a reasonable basis for them to be in contact with you.
No, it's not, ma'am. You're wrong. I'm an attorney.
I can't issue an order if they're doing their job.
That's not what's happening. If they have an injunction harassment, they can serve it. You don't get to call me and ask me to. That's not, ma'am. I literally, my wife's an attorney. I'm not trying to argue with the judge, but you're wrong.
Okay.
And so
Okay.
This person is not contacting me in the capacity of serving me an injunction. They're alleging they have one. Okay, they don't have one. They're alleging that to try to intimidate me to take down YouTube videos. That's all this is about. Okay.
Right. Well, hey, sir, let me.
If you deny me, I am definitely going to file a complaint against you.
Okay. If there is an injunction against harassment,
then they can serve me.
Actually, you can come down to the courthouse and sign an acceptance of service, and then they will stop contacting you.
But I tried that, ma'am, and it doesn't exist, and that's my point. You're gaslighting me. I'm telling you, if there was an injunction, they would have already been served. There's not, and they can leave me alone, and I absolutely can put an injunction on this harassment against this police officer. I told him twice, do not call me for any reason. He has no lawful reason to call me. If there is an injunction harassment for me, it's not Sergeant David Hill. Sergeant David Hill doesn't serve injunctions, ma'am. He's the emergency management threat assessment. You're wrong, though. They use the service. They served me one on Monday with the process server. So if I went to the court.
I'm sorry, sir. I'm not going to let you keep speaking over me, but here's what I'm trying to.
I'm not going to let you violate my right to get an injunction for harassment.
All right. Well, I think we're done here then. If you're not going to let me ask you questions and you're not going to answer my questions.
Go ahead.
If we're not going to cooperate, I cannot have a hearing with
Well,
you.
under Rule 9.2, you can't end it. So,
I mean, I can if you haven't stated a basis for an injunction against harassment. But here, you need to stop talking so I can ask you some questions.
Go ahead.
Okay. You have two instances listed. One on October 14th, which states you received a call about someone trying to serve you with an injunction against harassment.
No, wrong. They called me and said they wanted to talk to me and meet with me. The injunction, they didn't say why. I asked them why. They said they wouldn't. Listen, they called me, this guy, not they, David Hill, called me, and I started asking him questions why he's calling me, and he wouldn't tell me. And he said, that's okay. You don't want to talk to me? I'll find you and catch up with you. I said, okay, that sounds like a threat. So I called the FBI, who I've been working with. I have a case going with the FBI against the city of Tucson. I immediately called the FBI, and she looked into it. The agent, I'm not going to say her name right now because this is being recorded, but you can verify all this.
Fine. I don't need it.
No, I'm saying, but it's all verifiable. And so I'm not making false statements under oath. And so she told me, listen, you can ignore him. You can tell him to leave you alone. He has no legal reason to be contacting you. That's if he has an injunction for harassment, then he can.
I'm gonna let you know something. There is a legal reason for him to be contacting you. Here's the deal, though. Nobody can tell you who the injunction. If there is an injunction filed against you, they can't give you the name of the person until it's been served.
What is the legal reason that Officer David Hill can contact me, ma'am?
I'm assuming he's trying to serve you with an injunction against harassment.
Why would you assume that when I already articulated to the court under oath that I went and verified with both courts that there is no injunction against me?
And I'm telling you, sir, that you are likely incorrect.
Didn't you just state for the record that I could go to the court and accept service? Well, I went yesterday, and I have a YouTube video on my channel. Okay, so you
can come to the court and accept service of an injunction against harassment.
How do you accept service of an injunction harassment that doesn't exist? Because I came to the court to accept service, ma'am. You're gaslighting me, ma'am.
That one does exist.
I came to the court and they said one doesn't exist. So now you're saying you.
I don't know who you spoke to.
Okay.
I don't know which court you went to.
City court and justice court.
I know that there is a valid order that has been issued against you, and I can't give you any more information until it's been served, and I'm sorry about that.
So your statement for the record, there is an order issued of injunction for harassment against me?
Yes.
That doesn't.
At least there was as of the date that Mr. Hill last contacted you.
And what I'm saying is that doesn't preclude you from putting an injunction against harassment against Mr. Hill. They can just, ma'am, they can have somebody else serve it.
Okay. I am not permitted to issue, and I can't find that he's harassing you if he's trying to...
Ma'am, I told him to not call me, and he continues to call me. That's the very definition of harassment, okay? I told him don't call me. He continues...
Okay, I admit it, I have fallen down the Meyers rabbit hole. I don't know that there is any saving me at this point. I cannot believe some of the stuff that comes out of this guy's mouth. Now, we are going to be listening to yesterday's court appearance just because it is absolutely insane. You have to hear this. But I wanted to start the video with this clip because he not only claims that he's an attorney, his wife is an attorney, but he defines what he considers harassment. I find that incredibly ironic considering his current situation. Now, Meyers is currently being held in jail with no bond where he will remain until trial. He is now facing 19 criminal charges, including 10 felonies. Aggravated harassment, stalking, intimidation. And he continues to repeat the behaviors that are getting him these charges. Here's one of the biggest problems with this entire situation. He has a group of people so convinced that what he is doing is legal that they truly believe that telling a woman that her children need to die, telling a woman that she deserves to be raped, telling a woman that she deserves to be shot, that she deserves to get cancer, is considered peaceful redress of a government entity. It isn't. You are just delusional if you think that. And I think a lot of them are going to be in for a rude awakening because I don't see this going well for Mr. Meyers. He is going to threaten the prosecution, saying that they have to drop the charges within 5 days. That is not going to happen because he is, just like his followers, delusional. Before we get started, thank you to all of my channel members and subscribers. If you are new here, please consider subscribing. I would most certainly appreciate it. But let's go ahead and get into this because I know you're going to enjoy this one.
I'm here.
You got to state your appearance.
I'm going to stand up.
You don't have to stand up. Just say your name that you're here.
I'm Meyers and I'm here.
All right. And then we have Mr. Parvin as your, not standby, advisory counsel. Thank you.
She didn't provide anything you told her to provide me.
Hold on. We're not there yet. A couple things I want to address. First one, computer on.
You know that information on the government website is...
Hold on.
Just let him talk.
Is it not personal information?
Hey, stop talking. I need to open up my computer first, okay? I need to have everything
today. As you know, we have all afternoon. Everything will be done today. We just wait for our turn.
I need to remind them early and often. Somehow they don't know that information on a government website is personal information.
You're gonna, if you want a trial, you'll get your trial. But just...
State employees don't even know they're state employees.
Hold on just a minute, Mr. Meyers. I just got to...
Yeah, I'd like you to put on the record how you think you're above the Supreme Court and you can overrule 122H. I want that on the record today because I got this order from you today in jail that says you overruled 122H. You don't have that authority. So I'd like you to speak into the record what gives you the authority over the Supreme Court.
Can you let him, he's going to give you time to make all your arguments. Can you let him open his computer and at least look over what's going on today?
Not really. I'm sitting in jail with no bond for some bullshit. And he denied the slap, and it's...
Oh, you got to stop talking. You can't be in here if you're going to talk like that, okay? I haven't asked to hear you speak yet. I'm opening my computer so that it's working, all right? Understood? And I'm not going to let you up here and talk if you can't pay attention and follow the rules.
The rules apply to you too.
Please, let
You
him
got to stop, or I'm not going to let you be in the courtroom.
He's going to give you a chance to speak. You'll see he's probably give you lots of
Just
time.
hold on. All right. So the court has previously ruled that no private recording devices are allowed in today's hearing. Per my previous order, like almost all hearings that I conduct, this hearing is being live streamed over the court's YouTube channel. It's accessible through our Pima County Superior Court website. It is a very good working, clear way to project the proceedings. It's hooked up to our microphones and everyone can hear it well. In addition, the courtroom itself is open to the public under Article 2, Section 11 of the Arizona Constitution, meaning anyone who abides by the rules and is polite can sit at the courtroom and watch the proceedings. All right, so we are here first on the state's motion to modify conditions of release, and that was filed on March 18th. It's called amended motion to modify defendant's conditions of release. And then we have Mr. Meyers' response filed that same day, entitled a response to motion to modify conditions. In addition, I am advised that in case IC 003692 that a bond eligibility hearing was held earlier in the week in that case, and that the court in that case found that the defendant's release conditions were revoked, and the defendant is held without bond in that case. And we find Mr. Meyers in custody today. So just to start out, Mr. Meyers, you're still on release conditions in this case, so you're not getting any credit for time in jail on this case. If the court imposes a bond in this case and you're held on that bond, then you'd be getting credit for time in jail. If you are convicted and are sentenced to prison,
I won't be.
hold on, and sentenced to prison, then you get credit for time served. So just hold on, just listen. So, Mr. Meyers, if you're, as you will recall, what we discussed at the last hearing, the state has alleged priors, which if they're able to prove those priors and you're convicted of a felony in this case, then you'd be prison only. I wouldn't have any discretion whether to send you to prison or to
Be going to prison.
Hold on. And if you're sentenced to prison and you don't have a bond in this case, you wouldn't get any credit, even though you're in custody on another case. So that's a very important thing for you to understand. Mr. Alves, would you agree that that's the state of the law?
Yes, Your Honor.
Okay. So, Mr. Meyers, the first question I want to ask you is whether you want me to impose a bond so that you get credit in this CR number for the time that you spend in the Pima County Jail.
You told me that last week, at the hearing, you told me that we were going to come here today and we were going to discuss, her motion, my motion.
Okay.
Like I said would happen.
So I asked you a question, and
You want me to agree to a bond?
I didn't say to agree. I want to know whether you want a bond so that you get credit. You don't have to, but you have that option to do so.
Wouldn't that be admitting to the violations?
No.
No, it's just bond. That would not go before the jury.
So you could put like $100 just for like technical reasons or something?
Yes, that's what I was going to ask for if I were still your attorney.
Just
Yes,
for
yes.
paperwork reasons.
Correct.
Well, I think they're going to drop the charges in the next few days, if they were smart.
Okay, that wasn't my question. Again, I'm trying to ask you a question and trying to get you to interact with you. You're having a hard time listening to
I'm
me.
having a hard time because you told her, you gave her a court order and she didn't obey
Okay,
it.
we're still,
Separate issue. It's just a question to help you out for this one technical
Yes.
issue.
Do it.
okay, so you want the court to impose a bond, and
I'm not admitting guilt.
No,
No,
you're not.
no, it's not admission of guilt. What date was he taken into custody? That
It was
Last
the
hearing.
20th at the last hearing when we did the Feretta motion, or when you granted his right to represent.
No,
himself.
it was the next day. It was not that day. You gave me the right to represent myself on a Wednesday, and then we came back on a Thursday, and that's when they put these bogus charges on me.
It's March 20th.
March 20th.
Mark.
March 21st.
No,
March
20th.
20th is the
20th is
Thursday.
better for you. It's an extra day.
What I'm saying is are we actually like talking about Wednesday or Thursday? 'Cause remember, the first day I came, we had the little hearing and I went home. The next day I came, I didn't go home.
Okay.
Where I should
Last
be.
Thursday was the 20th.
Thank you.
Okay. And Ms. Stiles, what is the amount that the defendants asked for a nominal bond? What would your position be on that?
Your Honor, I would ask for no less than a $5,000 bond, just given the nature of the charges. He is being held without bond in the other matter, though, so regardless of how much, he's not going to be able to post bond and get out of custody.
Until
All right.
you drop the charges.
Hold on. Mr. Meyers, I'm inclined to post a $500 bond. Is that something you could manage?
Well, I mean, it doesn't matter because they're playing games.
Okay. So as to that release condition, I'm going to order the defendant held on $500 bond in this CR matter effective back to March 20th. So now you're getting credit back from the date of your arrest. The next question would be
All those days will count towards my unlawful imprisonment?
correct.
Thank you.
All right. Next, I do want to talk about other release conditions, but before we get there, there are a couple things I want to discuss. So at the last hearing, I just allowed you, we had an interaction back and forth, and you had asked to represent yourself, and after finding that you knowingly, voluntarily, and intelligently waived your right to counsel, I allowed you to represent yourself. And today you're representing yourself, but you're having a hard time behaving yourself. And one requirement of representing yourself is you have to maintain the proper decorum in court. And if you can't do that, then I can't allow you to represent yourself. So self-representation requires you to appear and act properly in the courtroom. Do you understand that? Okay.
I'm a little frustrated. I apologize. I know
All
it's
right.
not you. It's just, this is all a big joke.
So, Mr. Meyers, I'll continue to ask you that if you want to continue to represent yourself. You do have the right
I know.
to request representation, and then Mr. Parvin could step in and be your attorney. As we get closer to trial, it would be harder for him to do so if he thinks that you're preparing, and then you try to ask him to step in at the last.
That's kind of
moment.
the thing. It's like we got to kind of like figure out how well I can prepare. If the state's not even going to provide me the things you ordered them to provide me, it's hard to prepare for
All right.
anything.
We'll talk about that, and I promise we'll get to disclosure.
So I could just at any time request. My thing is I'm about to appeal your. I don't even know what you were thinking in that special act slap, but I'm about to file ASU is about to take the case and file a special action.
Okay,
to get that
so
slap.
the way
So
that
I don't know if they can do that if I'm not representing myself yet.
well, that would be before the Court of Appeals. My ruling applies to the case
That's what
before
I'm saying.
me.
So I don't know if they can, I don't know if that's contingent on me being pro se in this case, that I'm willing to do it. I don't know if that's something that they can do. Like I said, it's all just been talked about this morning. I talked to ASU this morning. I'll know more later after this hearing. They're going to take the case and fight it because they know what's going on. So they're going to do the special action of the slap. I don't know if I have to remain pro se in the superior court for them to do that, because then it's like they're helping me as a pro se or whatever. So that's one thing that I don't even know how to get a hold of you if I wanted to get. So let's say Monday or Tuesday I get more information on that, and then they say, yeah, you can go back to Parvin and we can still help you. How would I even, so what, write you a note? I mean, because that's kind of like the thing here is I'm trying to get a feel for, because obviously, sir, you know, when I applied, put in a notice and we had the hearing about representing myself, that was under the expectation is I'd be at home with Westlaw, my wife's who's a lawyer, and Parvin helping me. Obviously, the state also knows that if I'm at home with my wife who's a lawyer and Parvin helping me, they're going to lose the case. So they wanted to play dirty games and get me in jail, and now they won't disclose. So it's like, well, if I have to rely on you, sir, you're the top dog here. You're the man with the power, and it's kind of contingent on how adamant you are with, because you told me at the first hearing it's too early for a motion to compel, right? Well, I've been dealing with these people for 9 months while they've been retaliating against me.
Hold on. I'll get to your motion to compel and disclosure, but I want to keep.
Well, it's kind of like I have to make my decision on if I can represent myself based on the quality of legal. Based on my ability to prepare. And when they're telling me at the jail is, well, which it might change now that you put the $500 bond, but I've been in jail for a week And they told me I'm not even allowed to use the law library because I'm not in jail on those charges. I'm on jail on different charges where Parvin's my lawyer, right? So now I don't know if now that you put a bond, because they said I can only do it with a court order. I was under the impression you gave me a court order last week that said I could represent myself.
Right.
And
Okay.
now they're saying, well, you can't represent yourself without a court order. I was like, well, I got one last week.
All right.
So I haven't been able to do anything.
All right, couple things. Let's just talk about your representation. So
It's
your
contingent on the equality of the. I can
understand.
if
But
I can
let's-
represent myself with confidence and have the documents, just like if I was at home, that's one thing. But if the state's gonna jerk me around and not put, then I can't actually prepare, and I'm relying on you to enforce that.
So let's just talk through this. So as to representation, in this case before me, you represent yourself.
Aren't they gonna come together though at some point?
Probably.
Okay.
Okay.
Well, then
Well,
I have to reapply to apply for those specific charges.
Correct.
Okay.
All right. So that is not, it's in the work, that system's in the works, but it's not to the point where it's assigned to me
Will
yet.
it all become the same case number?
No separate case numbers, and either side can ask to consolidate them. So, but let's talk about this. In this CR number, you represent yourself.
The one that I'm already approved.
Yes, correct.
Right.
The one we're here on today.
14
Okay.
charges from.
Right. So in that case, you represent yourself. You can have an arrangement with the ASU Law School. Whether they want to represent you or not is between you and them.
Not for criminal.
Not in this case.
Right.
But they could, if they file a special action in the Court of Appeals, that's before the Court of Appeals. I'm not involved in that. The only thing is, at the same time, you want a speedy trial. Now, if the Court of Appeals were to issue a stay because they want to decide that issue,
They're gonna.
then the case couldn't go to trial. Does that make sense? Okay.
Because it should have been thrown out by you.
Okay. So just be advised that I'm proceeding in my case. If the Court of Appeals issues a stay.
Yeah, they know that personal information on a government can't be on a government website.
Okay, hold on. If they issue a stay, it could affect the schedule in this
I don't
case.
care. This shit
All
should
right,
have been dismissed.
that's fine. All right. So, but you understand that your arrangement with the
I
ASU
know.
Law School, I'm not involved in that. Okay.
That's, like I said, I'm not saying that they came here to told me to talk to you about that. I'm saying that with the little bit of information I came with today, I haven't even had a chance to ask them because I didn't, we don't know what's going to happen today. I don't know if you're going to, I'm waiting to see, because I mean, you already, I don't even know what you're thinking, but now I'm going to see if you're going to actually uphold your own court orders before I decide to bring Parvin back or not. Because if you're going to actually enforce the Rule 15s on these people, then maybe I can represent myself. But if you're just going to let them get away with everything they've been getting away with up to this point, then it's already a mistrial anyways.
Okay. So let's talk about disclosure then. Ms. Alves, what's the state of disclosure in this case?
Your Honor, the disclosure all went out to Mr. Parvin prior to him representing himself. So then Mr. Parvin should be providing that to him.
That's not correct.
I do believe that he's had some of the disclosure because he's been reading it online, because he's been streaming.
She has the floor. Just let her talk.
So I know he's not without anything because he's been actively reading it
I have
to
the grand
people.
jury transcript. That's not disclosure.
Hold on, Mr. Myers, don't interrupt. I'm talking to her. I'll let you respond. Again, if you can't control yourself,
I'm sorry. I'm
just
objecting.
all right, just
So
let
you're
her.
saying let her talk and then
Then I'll
come
go back
and-
to you.
Okay.
Correct.
I don't
Right.
need to
Do you
object.
remember how that hearing went and I waited till the next day to make argument and it was,
Okay.
limited exceptions?
So,
Go ahead, Ms. Stiles.
so the disclosure was given to Mr. Parvin while he was still the attorney prior to it switching to Mr. Meyers representing himself. We now have additional disclosure that's coming in because of the new charges, but he does not represent himself on that case. That goes to Mr. Parvin. So that disclosure is still going to Mr. Parvin. So we are, in my office, we got to figure out what to do about that because he's representing himself in one case but has the attorney in the other, because I also don't want to be communicating with a represented party on a case where he has the lawyer. So I need some clarification on if I need to be sending the disclosure additionally to Mr. Meyers. My understanding before is that Parvin was also helping with that, but I do understand that Mr. Meyers has a right to have it sent to him directly when he's representing himself. So we just need some of that. As far as there's a lot of media in this case, and so I have to figure that out with the jail and how to get that so Mr. Meyers is able to then review his media. That also goes with their protocols for safety and things like that at the jail and their security issues.
And the media, are they put on DVDs, or what's the medium you use?
It just depends. A lot of times we put it on disk. We might be able to put it on a flash drive. So we'll just coordinate. I don't know how the jail will want us to give that to them so that they can then make it available to Mr. Meyers to review. And so that's something I have to work out with the jail. But once again, the issue is he's representing himself in one case but not the other, and so that's creating some confusion. But all the disclosure I say that we have sent to Mr. Parvin already.
And the disclosure would include police reports, which I assume have been disclosed.
Yes.
And then there are like voicemail recordings and then postings on YouTube, and that's the media you're talking about?
Yes.
All right. So, Mr. Meyers, how would you want, or so what Ms. Stiles is concerned about is, as to the disclosure, as to the new case, you're represented, so she can't communicate with you directly. So it would be unethical to do so. Go ahead. What do you want to say?
I want to say that this woman is a professional liar. First of all, stood here in court.
Hold on, Mr. Myers. We don't call people liars in court. Just make your argument.
What's the best way to say that if I believe? Okay, what is the? I know lying is a taboo word in court. Okay.
It is.
What is the best untruth, misleading?
Well, so the question is.
Because my thing is, last week we had a hearing, right? And I told you this was going to happen straight to your face last week, right? And she's trying to convolute the issue and gaslight the American people, right?
Okay, hold on, Mr. Myers. They've disclosed police. Hold on.
What disclosure we're even talking about? Because I want to make sure we're clarifying exactly. Because disclosure is a big word, right?
Okay.
There's 20 charges with probably 500 more coming, and so the issue when in this hearing today, in the contents of this hearing, when I use the word disclosure, I'm talking about something very specific, and that very specific thing I'm talking about is last week. Okay. She is right. Maybe they sent disclosure before, but what I'm talking about is they filed a motion to modify the conditions of release. They then filed an amended motion to modify the conditions of release. Neither one of those motions included any exhibits of anything they were talking about. So therefore, last Thursday, we came in here and I said, I don't even know what they're accusing me of. And she said, you should know. You make the videos. That I still have the right to be noticed. Now listen, I told you this before I got arrested that day, that in order to have this hearing today, I needed the disclosure specific to this hearing. I'm not talking about disclosure in general. I'm talking about in order to make arguments in this hearing today, I told you last Thursday to order, and that was what the motion to compel was for. It wasn't for the whole case generally. It was, we are having a hearing next Thursday to modify my conditions of release. Anything Rachel Stiles is going to bring up there, I need a copy of, even if I'm in the jail. You looked her straight in the face, and she goes, "Oh yeah, we'll make sure he gets it at the jail." They haven't given me anything, not one piece of paper.
All right, hold on. So, Ms. Stiles, is the disclosure that was going to be addressed today the same disclosure that affects the new case? Is that what's going on?
Yes, Your Honor, and it was disclosed to Mr. Parvin, and it was then presented at the no bond hearing.
It was or was not?
It was.
Okay.
So we had the exhibits at the no bond hearing. We had the videos, the clips, videos played. So he's seen all of it because it was all at the hearing, and Mr. Parvin had that. And prior to that hearing, I also notified Mr. Parvin of what the times were for the clips so that he didn't have to sit there and watch the whole video and know what I was going to have the clips of. So I provided all that information to Mr. Parvin. The difference is when we were dealing with the hearing on the 20th, is at that time, the new case had not yet started because the complaint hadn't been filed. So at that time, Mr. Meyers was solely representing himself at the end of that hearing. But then, because then the complaint was filed, he was taken into custody, the new case began, and he was appointed Mr. Parvin. Then again, I had to communicate to Mr. Parvin, and because that disclosure is for that new case, I had to provide it to Mr. Parvin, who is his attorney. Right. And so that's the difference of what changed from the 20th.
Okay, so Mr. Meyers, what Ms. Stiles is saying is that because you're represented in the new case, the rules of ethics require her to make disclosure to Mr. Parvin. I don't know why that's funny.
Ethics.
That's the rule.
She doesn't follow ethics.
Hold on. That's just the rule.
Rule 3.8,
She's
special responsibilities of a prosecutor. Rule
hold on.
3.81 is don't prosecute without probable cause.
Okay. All right, Mr. Parvin.
Ethics 3.6,
Mr. Meyers.
trial publicity.
Again, we got to stay focused here. We're talking about the person to whom she has to make the disclosure.
And so why did you,
Go ahead.
I feel like these people are just talking in circles. All right, Your Honor, look, at the last hearing, sir.
But she, hold on.
I get the nuances. Just let me, I see there's multiple nuances here, all right? So I'm trying to articulate myself in the best way to understand the specific nuance that I'm talking about. I understand all those little, this is what I'm talking about, sir. What day was it? Because I don't have it in front of me. What day did it was like the Monday, the 17th or something? What day did they file the motion to modify conditions of release?
The 18th.
The 18th, okay. They didn't include any exhibits with it. So whatever exhibits they had that day should have been included with the motion so even you could see them. And at the hearing, you had to order them to send them to you. You said, at the hearing, you said, I need anything we're going to talk about today, I need you to send me copies of, right? No, that should have been included in the motion. And it wasn't. So if it would have been included in the motion like it was supposed to, we wouldn't be talking in circles a week later.
Okay.
Because if they would have included, hey, we're filing this motion to modify conditions of release contingent upon this video, this timestamp, this, you wouldn't have had to ask her to provide it to you because you would have already had it. I wouldn't be talking in circles because I would have already had it before I went to jail. And we wouldn't be sitting here a week later with her having provided nothing, making excuses about Parvin this, Parvin that. Listen, you told her in open court, it doesn't matter if he's in jail, make sure he has it. Now all she has is excuses.
Okay. But again, there was an intervening event, which is that you were charged.
She knew that was there because she knew when I was going to walk out of court that day that I was going to get arrested.
No, there was no case pending. Once the case,
You knew I was getting arrested that day.
Hold on.
We talked about it. We said I was going to get arrested, and I even addressed it. And I said, if I go into custody, I apologize. When at the last meeting, or then at the last hearing, you knew I was getting arrested when I walked out in the hallway. That's why I was adamant and specifically saying, I'm coming back here in 1 week, and when I go to jail right now in 10 minutes, I have nothing to prepare for. You ordered her to turn whatever we're going to bring up today, order to me, right? And you also said, make sure Mr. Meyers has it. And then you told me if she doesn't provide it, we can continue, and all that kind of stuff. Well, she hasn't provided it, and there's no nuance between the new case and the old case. Where's the disclosure that was attached to the motions to modify and the motion to amend, amended, the first one and then the amended? Those should have included exactly, and she didn't. That wasn't even a legally cognizant motion because it didn't even include the exhibit that she was arguing. And then, so that means that 18th, 19th, 20th, she's saying, oh, I gave it to Parvin because you weren't yet represented. I'm not letting this stuff fall into the black hole. She knew we had this hearing today, and she knew that you ordered her to make sure I came prepared today, and it's her responsibility as the prosecutor to ensure that I am served just like I'm required to serve her. So we can go into this little nuance about this. I don't want to hear that she didn't know she literally knew the charges were going to come when I walked out in the hall. So she should have been prepared knowing, hey, this guy's about to get arrested and he's going to still have this bond hearing next week. And my ethical duties as a prosecutor are to make sure he has this information so he comes prepared. I don't want to hear I gave it to Parvin and Parvin has kids and the jail wouldn't let him. I don't care. You gave her a court order. She didn't follow it.
Okay. So, Mr. Meyers, first of all, I don't know when you're going to be arrested. I had no involvement. I know
I'm not saying you were involved, but we did talk about it.
We talked about it.
Cops were standing in the back of the room.
It was a possibility that
They were waiting for me at the back of the courtroom.
You got to let me talk.
I didn't even get to walk out of the court that day. Without going into jail.
Let me talk. At the time that we had the hearing, there was not another case pending. Once those charges were filed and you had a lawyer for that, she has to go through the lawyer.
On the new stuff.
Right. And that's
still the modified conditions of release hearing.
Okay. But you now have the stuff.
No, I don't.
All right. Mr. Parvin, what would the arrangements be for Mr. Meyers to get this information?
May I speak on this issue?
Sure.
So, obviously, for the arrest, I was forwarding. Disclosure was going to me before I was removed, And I would forward all emails. It's really actually real simple. And Mr. Meyers very clearly downloaded it because, as the state unfortunately mentioned, it's been, well.
It's not unfortunate.
Well,
It's the rule 3.6.
Let him
But
talk.
I'm explaining that's, I guess, further proof Mr. Meyers did get the disclosure. So everything from media included, it was easily downloadable. At that point, it's a lot easier when Mr. Meyers out of custody because I can forward the same media. He downloads it just like I do. Now, after Mr. Meyers was brought into custody, I was appointed on this and had it wasn't easy to get prepared that quickly for a hearing, but
Right.
Pulled it off. I have to review a lot of disclosure. Most of it's in media format that I can't get to Mr. Meyers at the jail. The jail's in lockdown half the time, which is a problem of its own. They did make an exception yesterday for me, thankfully, so I could talk to Mr. Meyers even though he was in lockdown. But in general, it's very difficult. I've given Mr. Meyers what I could in paper format. I brought a couple pages today that were emailed to me. There's not a lot of paper police reports. It is mostly media. I understand that the state is making arrangements for the law library so that can all be passed on to Mr. Meyers. Because obviously, I can no longer forward it to him in electronic form.
Okay. So, Mr. Myers, it sounds to me that the real problem is that this is in electronic media, and
That's
with
their
you,
problem.
hold on, with you being in the jail, it's hard to get it to
Then
you.
maybe they should let me out of jail.
That's a different issue.
Oh, well, they
But
let
Mr. Myers,
kidnappers out that beat their
hold on.
pregnant wife.
Mr. Myers, again, you got to be respectful. You're not being respectful in court.
It
Okay.
goes both ways, though.
Hold on.
No, I know.
We're talking. This is a technical problem of electronic media.
It's my life.
Mr. Myers, hold on. It's a technical problem of trying. Hold on. Just stop talking over me. The state is going to get you, and Mr. Parvin's going to work on getting you the media in jail. They just have to figure out how to do it.
And then the jail's going to say, you can't do that. or
But we'll
something.
have other hearings if that comes up. So
I mean,
that
it'll
so-
be a mistrial either way.
So that's where we are on that. All right. So it's not that people are trying to do something to harm you. It's that it's physically difficult to get electronic media to a person in jail.
Then
That-
don't hold somebody in bond who should be out on bond. You won't have these problems.
all right. Well, we could address that down the road. But you're being held in the other case after our evidentiary hearing.
It's some ridiculous bullshit.
Mr. Meyer, you're showing that you're unable to represent
I'm
yourself.
not able to represent are you saying because of using the word bullshit?
Yeah, because you're just being
Are
disrespectful.
you
and-
saying that's not allowed in here?
No, you
Okay,
can't
well,
talk
then,
like
my bad,
that.
my
Just
bad.
talk normally in
All right,
normal
well,
English.
To be honest, my normal is probably not courtroom.
Yeah, courtroom normal is we don't call people names and we don't use poor language like that. We just talk in a normal voice
You know,
with
to
each
me,
other.
I use the F word and
Yeah, we don't use that-
ordering something at the grocery store.
Yeah,
so.
we don't use that in
I
court.
get it. I'm trying to work with
Okay.
you, and because some judges, BS might not, some might,
So I want to talk about a couple of other things we have in this case. I know you want to file a petition for special action relief in the Court of Appeals, and if they stay this, then they stay this. But you've also told me you want a speedy trial, and so
well, I expected you to grant that, at least make him respond, because I don't even know what you were thinking. I haven't even seen a copy of your order either.
Hold on. Go to the higher court.
I know, but I'm saying, how come I haven't even got a copy of your order either?
it got mailed to you.
So I'm sitting in jail getting nothing.
Okay.
I can't even read it to talk to the ASU. I don't have it in my hand.
The people, Mr. Meyers, the people that are working with you, they have copies. I can assure you that I've given copies to the correct people who are working with you for that.
For ASU?
Yes. The
Okay,
person who
okay,
told me
okay,
what
okay,
they have a copy.
All right.
I can assure you that.
So I'm not going to, our next court hearing is on April 15th. And because we have the victims here today, I can also set that as a trial setting conference if no one objects. So we're going to be back in court on April 15th. And on that date, I want to set the trial date, but I want to tell you now what that date I'm going to set. So any objection to making that a trial setting
You're
conference?
saying that we're going to set it that day officially, but today we're going to broach it.
Yeah, I'll just throw out
informally.
Correct.
Okay.
Is that all right?
I have no objection to the April date being converted also to a trial setting date.
Okay.
Is it possible to start trial that day?
No. In part because if the other charges come through and you want to consolidate them, that's not going to happen that fast.
I'm giving them a week to dismiss them.
So the case management conference on April 15th will also be a trial setting conference. And the date I'm suggesting for trial is June 17th. My trial started on Tuesday. And we have that week.
It can't be any sooner? I'd like to start at April 16th.
So the speedy trial time in your case runs August 11th, so I just have to set it by that date. I'm actually doing almost 2 months before that, so,
I appreciate it. I mean,
all right.
In Your Honor, I will note that I did speak to the victim, and that date is a conflict for them for something they already have that's already been
it's my rights.
rescheduled.
Defendant's rights overrule theirs.
So your right is by August 11th.
So they just need to look at their calendars. So
Yeah, that's why I'm not sending it today, so.
So they get to jerk me around.
No, they're not jerking you around.
They've been jerking. I'm sitting here in orange handcuffs for showing a government website.
So, Mr. Meyers, the victim also has rights under the
Not the
victim.
victim. I'm the victim.
Hold on. The victim has rights under the Arizona
Alleged
Constitution.
victim. Let's use the right language here.
It's
Alleged
the word.
victim.
The word is victim in the Constitution.
It says right here, alleged victim.
All right.
I
That's
would
not
prefer-
a. That's not a finding.
So you're
It's
saying
just-
that by saying that it doesn't indicate that you've already determined she's the victim? Because it
I haven't-
bothers me to hear somebody call somebody a victim who hasn't even been convicted.
That's just it's a legal term of art
Is
under
it
the
alleged
Arizona
victim?
It's not called alleged victim in the Arizona Constitution.
All right.
There's victims' rights.
I get it.
That doesn't. I don't say that before the jury.
Okay.
That's just like you're called the defendant.
Mm-hmm.
The state is called the state. They're just
I'm Lane Meyers.
they're just labels. You're Lane Myers, but in legal things you're the
I'm not
defendant.
a defendant. I'm a victim
Okay, so
of unlawful prosecution.
so we set this. I'd like to set it for June 17th, but we'll have to see if that works for everybody. If not, then I'll set it in July. All right. Look at my list here.
How many days?
So it would be the 17th through the 20th, and
How are
then
we going to watch 49 hours of videos in that many days, in 8 hours at a time? That's 6 days of just watching videos.
so the rules of evidence would not allow
We're going to have
that.
rules. We're going to have the rules of completeness. We're going to watch every minute of every video I've ever made.
You're gonna have to
Okay.
file your own motions here.
Okay.
Motions
So-
I would file that might be
so-
different than you. But
We're not going to take my videos out of context.
All right. There is a rule of completeness, but there's also a rule of relevance, and that it not be duplicative or wasteful of the jury's time. Those are both rules. You can look them up.
Even having trial is a waste of the jury's time.
All right. So that's what the schedule is. The next thing I want to talk about is release conditions. And I'll start with the state.
So we're going to have the hearing even though they haven't provided the disclosure?
You've already stipulated to a bond. I'm just talking about the release conditions.
The modified condition or whatever?
Yes.
So are we going to have the little hearing?
We're just going to talk through that now. Ms. Stiles, currently the release conditions are the defendant have no contact of any kind with the victim or victim's family. The defendant not go to the victim's residence or workplace or victim's family workplace, and to take the videos of the victim down. What would the state's proposal be as to release conditions if they should be modified?
Your Honor, so to be clear, the state did not bring things to do another evidentiary hearing since we did have the no bond hearing.
Okay.
I just want to make that clear because then now it's already been established by proof evident presumption great that there were new felonies committed while on felony release. The concern the state has now is that Mr. Meyers, while he's in jail, is he's sending messages to other YouTube people in order to ask them to live stream. He then will call them so that they can then live stream him from the jail. And in doing so, he is now calling upon the followers to essentially continue to harass people involved in this case.
Objection.
Hold on. She has the floor. Go ahead.
So that includes that he's calling on them to contact the court. In his words, he said,
Don't interrupt her. She's talking. Just wait but you just got to sit.
remember how I had to wait the entire time?
Yeah,
And
yeah,
I only got the chocolate.
My
Okay.
ADD kicks in when I hear lies.
I had the floor almost the entire day during your bond hearing when it was my turn. That's not
Okay.
how it works. You take
Go ahead, Ms. Stiles.
so he's called on his followers to roast the court. He's been going through things. He's been reading things from the grand jury transcript, which is also protected by statute that he's not supposed to be reading from the grand jury transcript. And so he's putting all that information out and it's going out into the public. And what I am concerned with is we want to maintain the integrity of this case and in the integrity of the trial that's going to likely take place in this case. And with him actively going on and live streaming, he's continuing the same behavior for which he's in custody now. So it's putting the victim is continuing now to get harassing emails and voicemails, and we are having issues with everybody involved in the case where they're trying to intimidate people in the process to influence the case, which is improper. And so I have concerns about his access, at least to, I take very seriously somebody's ability to communicate with people when they're in custody. But if he's using that ability to communicate as a weapon, that's going to harm the integrity of this trial and harass the victim and harass the people involved in this process, then I don't think that he should have that ability to do so. So I am asking for his ability to be the restricted, that he not be able to live stream from the jail.
Can't do that.
And if he is not able to comply with that, then I'd be talking about the phone privileges. He still has the tablet, but I'm concerned with the live streaming.
So, what's the policy of the jail, if you know, for people in custody to use the telephone?
So my understanding in inquiring from them is they can't use the telephone, so they can't ask them to be connected to a third party. So if they call person A can't then, three-way call with person B. It doesn't sound like the jail was prepared for this. They hadn't had this come up where he would call, person A, and then person A would be live streaming him,
The news
on
does
the
it all
media.
The news does it all the time.
He's talking. Just be quiet. Go ahead.
And so it sounds like the jail's visiting that issue right now, but I don't know what they're doing with it. And if he wasn't doing it in a way where he's calling upon people to harass members of people who are involved in this case, and that is also causing the harm to the victim, I don't think it would be the same issue. But the problem is that is the very nature of what his conduct was that got him the criminal charges in the first place. And he's still, even though he's in custody, he's still using that means to cause harassment to the victim and harassment and intimidation to everybody involved in the process. And so that is my concern, is he's posing that ongoing danger to the victim, and he's causing the implications for the integrity of this trial.
So what would your remedy be?
So I would ask for an order that he not be able to participate in live streaming, and then that's where I would start. And then I would hope that if he was ordered to do that, he would comply with that. And then then that would also give the jail, if they find out that he is live streaming, then they could then take action to stop it as they needed to. I think that's the least restrictive of the options, because that way I don't want him to lose his phone privileges where he can't communicate with people. But I want him to not be live streaming about this case, causing that further harassment. So like I said, I believe if the court restricted him from live streaming on it, then that would allow the jail to take action as necessary.
All right, Mr. Meyers, your response.
Can you pull up I don't have the computer. Can you pull up rule 3.6 of the Model Rules of Professional Conduct, trial publicity? Thank you.
Nope.
I want to start there. Rule 3.6, trial
Yeah,
publicity.
hold on. I'm getting there.
He was going to look it on his phone, that's what I was saying. Rule 3.6, trial publicity.
All right. A lawyer, this is 3.6.
Yep.
A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make any extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Notwithstanding paragraph A, a lawyer may state the claim, offense, or defense involved, except when prohibited by law, the identity of the persons involved, information contained in the public record, that the investigation of a matter is in progress, the schedule or resulting steps in the litigation, a request for assistance in obtaining evidence or information necessary thereto, a warning of danger concerning the behavior of a person involved, where there is reasonable to believe that there exists a likelihood of substantial harm to an individual or to the public interest, and in a criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, and family status of the accused, If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of arrest, the identity of investigating and arresting officers or agencies, and the length of that investigation. C, notwithstanding paragraph A, a lawyer may make a statement that is a reasonable lawyer would believe is required to protect the client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. No lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. That's the rule.
Yep, can I go now?
Yeah.
All right, so as we can see right there, I can talk about information contained in a public record, police reports. I can state the claim, how I plan to defend it, the identity of the people involved, the scheduling of the litigation, what happened at my last court date, hey, can anybody help me, information or assistance? I can warn the public that the person who's putting these charges on me is a danger to the public because they don't know they're a government employee. I can say that in a criminal case, I can talk about the identity, residence, occupation, and family status of myself. I can talk about myself. I can I can talk about the facts, the times, and the place of the arrest. I can talk about the cops who came to the court and testified, the arresting officers, and the most important though, C, a lawyer may make a statement that a reasonable lawyer. For the purposes of this discussion, as pro se, we're calling me a lawyer, right?
Yes.
Okay. So, especially C, a lawyer may make a statement that a lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Well, I sure didn't put these charges on myself, and I sure ain't out there telling everybody that I got my slap. How did they know my slap got denied? Somebody leaked it. So how am I not able? I am allowed to correct the public record. I am allowed to say, I know they're accusing me of this, but it's not true. I'm allowed to defend and I'm allowed to say.
There's a difference between what you're saying and what's being alleged.
But what's being alleged?
Hold on. What's being alleged is that you are giving information encouraging others.
But that's not true.
Harass.
That's not true. Where's the evidence? Where's the evidence? I have never, ever, and that's what you're gonna find out, especially your little slap motion. I've never, ever in my entire life told anybody to contact this woman under any circumstance. In fact, I made 2 videos saying do not contact Shannon Walker, and we're gonna play that at trial.
Okay, editing me here. So I had to insert this clip last minute just because it specifically relates to what he is talking about right now. He is talking about how he has never instructed anyone to contact Shannon Walker, and that is just false. The audacity in how much this man lies is just next level. Now, this is a clip from one of his Shannon Walker videos back in October, where you specifically hear him say, "This means us calling is working." So he is aware that his actions are causing people to call her and harass her.
You know us, we love when they do things right in front of our face like they're going to get away with it. We can call them out. I got to give you this little quick one. So Shannon Walker, Matt Walker's wife, if you notice, they took her email and they took her phone number off here, right? So now they're going to say it's not public information and you're calling a non-public number and all that, but really all you got to do is call the switchboard and ask for her number and they'll give it to you. But anyways, I'm going to post her number up anyways because this isn't going anywhere. This is only getting started. Like I told the cop who wants to serve me the next injunction harassment, come find me, bitch. Originally, I was going to meet with him at the FBI office, but now I told him, come fucking find me, bitch, because if he thinks he's going to serve me an injunction for harassment with a public employee's name on it, he can come find me. And then he can shove it up his ass. And that's for you, bitch, Bob. Bob Hill. I don't even know if Detective Hill. But anyways, look what Shannon Walker did. Yesterday it was on here, right? Today it's not, right? So see how that works? That means that us calling is working. So if she doesn't want to so there's still her email, it's public. And then let's just call the law college main number. Let's see if we can do this. Okay, I've made it explicitly clear. People can she forgets that the First Amendment, people can address the government. People can call you on your government phone. That's why it's listed. Okay, that's up to you to decide, not her. She doesn't want me telling people to call the judge.
Well, guess what? Take your number down. There's no crime in calling the judge. That's why your number's on there. It's the First Amendment. This is all they want to retaliate more against me because I'm having the public participate in making sure the whole world knows how innocent I am. I'm allowed to go on the news. People do interviews from jail all the time on the news. All the time. People give interviews that are broadcast on the news all the time. I've never one time told anybody to contact the victim, alleged victim, Shannon Walker, whatever we're calling her, which won't, because I'm being charged for saying her name in a court hearing. So I don't even know what I'm allowed to say and what I'm not. But the most important part is she has no proof. She literally just came in here and said all that and doesn't even provide any proof. Show me right now. Why am I not charged then? So if I told everybody to contact the victim on a live stream, why am I not being charged? Because it's never happened. I've never in my entire life told anybody to contact this woman at any point in my 42 years on earth, okay? So for her to come in here and say, oh, he's on the live stream, I have the right to do that. I can go on there and say, hey, friends and family, I'm doing all right. This is what happened at my last court date. This is what's going on. This is what I'm going to use for my defense. This is what the evidence is. This is all under a bar. And that's what you should have saw in my slap motion. A bar attorney, a member of the bar association could hold a press conference and say, yeah, we got these police reports, and they say, yeah, he's her ex-boyfriend, even though he's not her ex-boyfriend. And we want to make sure that we let the whole public know that at no point were they ever in a relationship, despite a police report being signed under the penalty of perjury that it says that I'm her ex. So obviously, you signed a police report under the penalty of perjury that I'm her ex. I have the right to go on to tell the public I am not her ex. That is not a crime. But I'm being charged for making a video saying, I don't know why it says in the police report that I'm her ex. I'm not her ex. I've never even met this woman. So I absolutely, can you pull that back up? Specifically to correct the inaccuracies of the public. If people are out there thinking, this is his ex and he's harassing her. I mean, how am I charged with domestic violence? I've never even met this woman. This is insane.
I don't think you're charged with domestic violence.
Of course I am. It says right here, 3 counts of domestic violence.
Hold on. I have the indictment.
The new charges that we went to court yesterday, I'm charged with 3 counts of domestic violence.
I have the indictment right here. You're
No,
charged.
not the first one, the new one from the 2 days ago.
I don't have the new indictment.
It says that I'm charged with 3 counts of domestic violence. I've never even met this woman. So of course I'm going to go on there and say, how am I charged with domestic violence? I've never met this woman. It's not domestic violence. I've never met her. So if I'm holding a court document with my name on it, it says you're charged with 3 counts.
Slow down.
That you're charged with 3 counts of domestic violence, and I'm saying I've never met. It looks bad. Domestic violence is a terrible thing. Harassment, all that. I'm literally holding an email right here that says, this is from me to Matt Walker, months ago. I do not condone those crazy messages in any way. I had no idea those were being left because I wasn't the one leaving them. I don't know the tone of the voicemails because I didn't leave them. I do not encourage or agree with that and would never want my wife to get those either. Talking about crimes is way past what we are doing here. I'm talking about crimes. Alleged. I am going to make a video addressing anyone calling on my behalf. Better not ever do that. Or they should
Slow down again.
Sorry.
The court reporter's got to take down what you're saying.
All right.
So we're getting far afield. Mr. Meyers,
Mr.
Meyers, we're getting far afield here.
Well, no, she's trying to take away my ability to talk about my case and talk to my supporters.
I'm trying to ask you questions to be able to make a decision, and you're just talking nonstop. So let's focus.
So you want to do like a back and forth?
Let's just focus. Yeah, Mr. Meyers.
Well, I had a couple more points.
Hold on. I want to ask you some questions. You've talked like nonstop for several minutes now.
I'm scared. I don't know when you're gonna cut me off.
I'm not going to cut you off. I just need to talk.
Go ahead.
We need to focus. Okay.
I'll hold my hand or point at me or something.
So here's the question. Do you know, first of all, that I'm assuming that the jail is recording all your calls?
Of course.
And are you saying in those calls that you're not making any statements to anybody to encourage them to contact the victim?
Never, ever in my life have I ever told anybody, whether in jail, whether 6 months ago, whether today, tomorrow, or the next day.
I have your point. So let's hear from Ms. Stiles to see what her position is on that, okay? So that's what you've said, that you've never done that.
At jail.
In the jail calls, right.
So just want to make sure we articulate this properly. You're asking me, because she said that I'm making statements on live streams for people to contact the victim. Never, ever.
Okay.
So do we use the word lie or do we use
Hold
the word
on.
manipulate?
I
What do
want
we
to
do?
hear. I want to hear what she has to say in response to that. So now Ms. Stiles has the floor, and you're not going to interrupt her while she
Sure.
talks. Go ahead, Ms. Stiles.
So, Your Honor, as far as the victim, he's not saying directly call her, but he's making other statements, and his discussion is encouraging that same contact. And then I would note that he's communicating with a YouTuber who has the victim's information posted on his page constantly. So when he's live streaming with them, and maybe Mr. Meyers does not know that the person he's communicating with is keeping up her contact information. But so he's doing the live streams, and then that is then encouraging that contact. And then as far as the court reference, he has absolutely told his followers to roast the court.
Is that the word he uses? Roast.
Roast, yes.
Uh-huh.
He provided a description
I thought we were talking about
Let her talk. Let her
He
talk.
provided your description. He was giving your description to this YouTuber that was being live streamed. He was making sure he was directing the website for the court so they would all know how to find your information to contact the court. And so that's where that is coming from. There are so many jail calls. I have not been able to go through all of them. But like I said, I have people emailing me from the public who have concerns about the information he is posting on these live streams, and they are reaching out to me and concerned for the victim. And then the victim is also continuing to get harassing phone calls and emails. And so that's where I have the concern. There's also the information about, my office, but that's not the concern I have with the trial itself. My concern is reaching out to the court and, of course, harassing the victim.
my turn.
All right, hold on just a minute. So I'm inclined to have a hearing on this on Tuesday, if we could, where you could bring that information in and we would have a record then.
Yes.
Mr. Meyers, I'm inclined to hold a hearing on that.
Can I say something real quick?
Yes.
Not only is she, whatever you want to use the word that we don't use in court, we've went out of our way to make sure that any live stream, not only that, we paid YouTube money, sir, to block the word Shannon Walker. So at no point has any live stream I've been in from the jail used her name. You can't even, we paid Google because we're so worried about them doing this crap that my live streams, we go out of our way to, because, a live stream, because you might not be up on the technical nomenclature of like YouTube live streaming and shit. So I'm going to give you like a little technical jargon, okay? So when you're doing a live stream, right, you go on YouTube, there's a live stream, which it includes like a little chat, right? There's like, so people, like whatever you're watching, people can kind of like comment down in the corner like, oh, right. We've paid YouTube money to make sure that the words, we put banned words, Shannon Walker, Matt Walker, all this kind of stuff. We paid YouTube to make sure that because we know they're watching. I would be an absolute moron to sit there on a live stream showing the victim's information. And that's not what, now, she keeps calling him my friend. No, she has the paperwork and she's about to get served with an injunction because she keeps calling a news media corporation registered in the state of Florida my associate, and she's been put on notice with a notice of claim already to stop doing that. And now that she did it again in this court, she will be hit with defamation, probably by the end of the day. And so you cannot, that is prejudicial, sir. She is trying to prejudice you against me by saying that I said call the court. No, what I said is before the slap motion, my wife, who used to be Judge Gordon's law clerk, said, if anybody wants to write a nice, respectful letter outlining why they believe this is a retaliation against public participation with the court, they can do so, okay? Nobody's encouraging the court to be rude to the judge or any of that.
Go to the Superior Court website. Can you show the screen right now?
Yeah.
Go to the Superior Court website.
All right.
Judge's information.
All right.
Show Judge Metcalf's phone number. Scroll down, show Judge Metcalf and highlight it.
There it is, folks.
Hey, everybody, call Judge Metcalf on his personal phone number, please, and let him know he's a fucking idiot who doesn't know the difference between information on a government website and personal information. Tell him you got his personal phone number off a government website. Go ahead and call there all fucking day. From now until the time I'm spending the rest of my life in prison, call Judge Metcalf and say that you want to talk to him on his personal phone number that's listed on a government website. Roast him.
That'd be.
So, Mr. Meyers, what I suggested is to have a hearing so we can hear this information.
Why didn't she come prepared? She's in here slanging mud on me and doesn't even have anything to back it up. I could come in here and just make up whatever then.
Because it just has happened.
Trying to prejudice you, sir.
No.
Why is she bringing up the court?
Don't talk over Mr. Myers. Don't talk over me.
Go ahead.
You gotta lower it down. It's not helping your case to scream.
There is no case.
Okay, there is a case. You're in custody, so there is a case.
For now.
So
for
Mr.
now,
Myers,
for now.
what I am suggesting is to hold a court hearing so that I don't want to argue about this.
I see what you're saying without anything like visually.
Yeah.
Right, and I want to say the scope of the hearing. You cannot bring in anything about the court because the court isn't accusing me of it. The prosecutor doesn't get to bias the court against me by saying that I said call the court. Your number's on the website, sir. I know you don't understand the difference between government information on a government website and personal information on a government website, but if people weren't allowed to call you, your number wouldn't be on there. And Rich Tracy's standing right there, and he gets all the emails and the calls, and nobody's been charged, okay? I've been dealing with you guys for 9 months, okay? I know the deal, okay? People been calling Judge Walton because she lied under oath. People been calling Judge Weiland. Hold
on, Mr. Myers.
She's attempting to turn the court against me and bias you against me by implying that I've somehow did something untoward towards the court. I said people are allowed to write the judge letters, good or bad. There could be just as many people calling saying Lane's a fucking idiot. He's with or without me. She is literally picking at needles in a haystack because she's so scared that I'm going to win this case because the whole world knows what's happening and she wants to take away all I have, my emotional support live stream where I go on there and talk about what I believe is happening to me. I would be an absolute freaking fool to go on a live stream that I know that every cop in Pima County is watching as it's happening and say, contact the victim.
Okay.
That would be suicidal.
So what you're doing is you're speculating on what's in the content because you're speaking. I don't know what's in the content yet.
The video you're saying at the live stream?
Yeah.
I've never told them to do anything towards the victim. I've never said. In fact, this is what's really going to come out at trial.
Mr. Myers, hold on.
They keep alluding to this fact that this word encourage. How do you define Webster's defines encourage as? You can't silently encourage somebody. So for her to say,
Mr. Myers, hold on. We're getting far afield, and you're really, really amped up.
Because she's making false accusations.
No. She's saying that I'm suggesting to have a hearing, and she's going to bring this stuff in.
Well, why did she bring it today?
Because we just addressed it
at me and let it stick at the wall.
We're going to have a hearing. You seem very scared to want to have this hearing.
Oh no, I want to hear. No, I'm saying I'm scared. Okay. I'm not scared of nothing, bro. I'm not.
Again, you're being disrespectful now.
Scared is the least thing I'm worried about.
You seem very scared to me.
Scared of the hearing?
Yes.
Bring the tapes
why.
In.
What?
Play them.
Okay.
If I.
Mr. Myers.
All you have to do is make sure that there's nothing temporary until the hearing. As in you can keep doing what you're doing.
Right.
There's
nothing.
All you have to ask for.
I'm not scared of anything because I know I'm not doing anything wrong.
Mr. Myers, just request that you can keep doing what you're doing until the hearing.
My frustration, what you're calling might be scared, my frustration and my... I want a second. What you might be taking as scared, I'm definitely not scared. These charges are bogus. What you're referring to as my apprehension or whatever you want to call it.
Scared.
I'm saying like you're calling it scared. I'm not going to use that word because I'm not scared. It's more frustration that if you're going to come in here and accuse me of making a live stream contacting the victim, you should be prepared to show the judge that. If you're going to come in here and make allegations that I'm telling people to do this or that to the judge, she should be able to show that right now. We shouldn't need another hearing. She should have came prepared to back it up with receipts.
That wasn't the purpose of today's hearing.
Then why are we talking about it?
Because we're going to set another hearing because you raised the issue. But this isn't the evidentiary hearing today. You got to. We talk about getting preparing things and then hold a hearing on what we're going to show.
She already prejudiced me by stating it. You allowed.
He hasn't prejudiced you yet.
Told me she just stood here in open court and said that I told people to contact the victim, and then when you went back to her, she said, well, actually, he didn't actually say to contact the victim. So which one is it?
So, Mr. Meyers, again, you seem very apprehensive about me setting this hearing.
No, I didn't understand what you meant
Myers.
about a hearing.
Mr. Myers.
Set the hearing. As long as
Okay.
the
How about-
status quo remains, status quo remains.
Just, I think I know why you're nervous.
I'm not nervous. Stop saying.
Okay.
No,
Mr.
I'm
Myers.
not nervous. Okay.
Nothing changed.
I'm not nervous.
Make that one request. Just ask.
The status quo needs to remain in place, and we'll find out at that hearing who's lying, me or her.
That's all you have to ask for.
So I'm going to set the hearing at Tuesday at 1:30 p.m. if you all can appear then.
Yes.
All right. So that hearing will be Tuesday at 1:30 p.m. and that's on the ability of the defendant to make statements from the
You
jail.
can't take that away from me.
That's what the point of the hearing
It
is.
doesn't matter if we have 10 hearings. You cannot stop me something that the Bar Association gives me the right to do.
So,
the hearing.
Mr. Myers, I get to make decisions. If you don't like my decisions, you can go to the Court of Appeals. That's the system. You can't threaten me like
I'm not
that. You did threaten me.
With what?
You just said that I can't make a decision.
No,
You
I said you can't take away my ability to talk
Okay.
about my case. It's literally a Bar Association rule. You would be in violation of the ABA.
I can do that.
You gonna put a gag order?
I didn't say I'm going to, but I can.
No, you can't.
Yes, I can.
You can't. I'm my own lawyer. You can't take away my ability to talk about my own case. You're getting into uncharted
Again,
territory.
you're threatening me again.
I'm not threatening.
You are threatening me.
How am I threatening you?
You're saying I can't do something when I can.
You can't.
Okay, so that's another threat.
It's my belief. It's not a threat. It's my belief. Why? Then what is the Bar Association thing we just read? Are you saying that
I
you
get
can
to-
overrule that?
Yes.
Okay, then that's my misunderstanding. It was.
All right.
It's not a threat. It's a misunderstanding.
Okay. And if you don't like my rulings, you have the right at any time to file a petition.
But I don't even have a pen and paper.
Mr. Myers, I just told you. You have the right if you don't like
Just
any.
told me I was
Oh,
scared.
Hold on. You were scared.
I'm not scared of anything, bro. That's what you don't understand.
Okay, so hold on.
I'm definitely not scared of these bullshit charges.
Hold on, Mr. Myers. We're getting far afield here. If you don't like my rulings, you could file a petition with the Court of Appeals saying Judge Metcalf made a mistake, reverse him, then it comes back to me and I file that Court of Appeals ruling.
What do I file when I don't agree with the prosecutor's lies?
You bring something up here.
So do I have the ability to request hearings also like she does?
Of course.
So I can bring up, so is that something I just send you in the mail or something?
You have to file a motion.
Yeah, because it seems like
You're very good at filing motions, Mr. Myers.
from home with Westlaw with my wife who was a law clerk for a federal judge and Judge Gordon, yeah.
All right. So, are you still married?
She,
Wait, she can't still help you?
from jail? No, she's not my attorney.
Okay.
She has a job,
All right.
and they already got her fired from one of them.
So, Mr. Myers, we're going to have the hearing at Tuesday at 1:30.
Determine if there's truth to their statements about me telling them to contact the victim.
Correct. Or to harass people. Remember, this
Harass
is
people.
harass.
What does that mean?
There's a
Oh,
statute.
you can't that's legal jargon.
It's not. It's defined in the ARS.
Jargon.
It's not. like-
Tell me my
No.
conversation is harass. You're not a law enforcement. And tell her she better come with some indictments
All right.
on Tuesday.
Ms. Stiles, anything else?
Your Honor, I don't know if the jail needs you to order that he have access to the law library, but we want to make sure
Okay.
that that's
Yeah, they
clear.
said I need a court order.
All right. I'll order that you have access to the law library in this
On both?
CR.
On the CR that I was originally, like the 14 counts and all that, right?
Correct.
But there's so is that going to change now? Because you already gave me that and they wouldn't take it. And so
It's in the order. It'll be in the minutary.
then because the COs just get mad when I try to argue with them.
Well, maybe you shouldn't argue with them. Just talk to them politely.
I said I have a court order. They said no, you don't.
Mr. Myers, yesterday, they didn't want to let me in.
See what I mean?
I talked to some supervisors. They understood why I needed to meet you, and they made exception for me, even though there's a lockdown.
that's
There's
him.
a lot you can do by
I
just
don't
being
get
calm.
I don't get exceptions at the jail. I'm wearing orange.
Okay. There's an order in the minutary. Anything else we need to discuss?
Your Honor, just that I think that last time the court didn't make a specific order regarding the law library, but now that that order is specific to that, that should hopefully allow him the access with the jail.
Okay. And Mr. Myers, I'm going to continue to raise this throughout these proceedings. The way that you're behaving today, if you behave that way before the jury, they won't like that.
I
And
don't need legal advice from the
okay.
judge.
Well, I'm not giving legal advice. I'm just making an observation.
All right.
And that's something you need to keep in mind. And I'm going to keep reminding you about that, about whether you want to represent yourself or not.
So I'm not supposed to take that as you being condescending?
I'm not being condescending. I'm just saying the way you're behaving today would not benefit
Jury's
you.
not here, are they?
They're not here today.
So I'm a pretty intelligent guy.
Okay, that's good.
Your Honor, then one question. So I'm obviously going to have exhibits for the Tuesday hearing.
Uh-huh.
I just don't know how to get those to Mr. Meyers because he also has Mr. Parvin as his attorney. So because we're going to have jail calls, we're going to have the YouTube videos. So
This is ridiculous.
Hold on.
Am I being charged with these crimes, or is this just to taint the judge?
Can you reappoint me for that one hearing only?
We're having
Yeah.
a hearing.
Will you let him be my lawyer for that hearing only?
Well, let's talk to Mr. Parvin first of all about how you think we can get this information to Mr. Meyers. Do you have an idea?
Which information? Well, obviously today I printed out something that was just sent to me. I was able to give to Mr. Meyers. Anything paper's not is as long as the jail's not on a lockdown, it's pretty easy to get it to him. When it's a lockdown, it's a lot harder. Unfortunately, there's a lot of lockdowns for the jail lately. But for media, that is a lot tougher. I can get permission to go down with a computer or phone. So as long as it's monitored, they'll let me use the media to show him as I show him what I'm. But it is hard to give him actual media unless he can go to the law library and download himself.
Hold on, Mr. Meyers. Can you go there with your computer? Can you bring your computer in with you?
My currently, my phone has everything. That's right down on my audio. They don't like phones, but they usually allow it if there's a special. I'll say I need to show my client something. They will let me bring a phone for that purpose to show them audio. That's where I download most of it.
Okay. Ms. Stiles, any thoughts?
just normally the attorneys are able to bring a computer and do not have a laptop.
Since the technology is so much easier, I just use my iPhone and plug everything in and just play it on screen. It's been great.
So maybe that's, Mr. Meyers, would that work if your client, your Mr. Parvin had the disclosure and he could go to the jail and just play it for you? Go ahead.
That's and I actually saw another attorney with the phone at the jail recently, so I know they must be making exceptions some of the time, especially now times are changing.
I want to clarify something about the scope of the hearing, because it went from live streams to jail calls. Now you definitely ain't going to tell me that my private calls that they're listening to that aren't broadcast, those have nothing. That's outside the scope of the hearing.
No, it's your calls with people on the outside.
But she said live stream.
Well, my understanding is that you're calling someone and the person on the other end of the phone is then live streaming that. You're obviously not live streaming from the jail because you don't have access.
Right, no, they're recording me too though. I'll call and we'll have just like a news interview with K-Gun 9, and then K-Gun 9 will broadcast it.
Right.
That's not illegal.
So the question is whether you can continue to have access to make those calls.
In Your Honor, so what I'd be intending for the hearing is he both sends messages to people to say that he wants to live stream, and then he goes on the live stream. I just want to make sure we have pulled a lot of those videos already, but in the event that they take them down before we have some of them, then we have the jail calls. But in the jail calls, he references and he asks them, are we live? And so that would be where if for some reason they pull down the video, I can then bring in the jail call to show that he actually was telling them and knew that he was streaming live with them.
Okay.
Why is that a problem?
That's what the part of the hearing is. We're gonna hear the evidence and then we'll make a ruling.
Why would it be a problem that I talk to my family on a live stream? Because calls are expensive. So why can't I call one person and talk to multiple people?
The question is whether you're doing that to harass people. That's what that.
That's what law enforcement decides.
Hold on, no,
the judge.
No.
So you're gonna make a legal finding of harassment?
So again, you're threatening me. You keep threatening me.
I asked you if you were gonna make a legal finding.
I haven't heard the evidence yet.
But no, I'm saying your inclination is that you think that so if you decide that you feel I harassed them, will I be charged?
No.
Then it's not a legal finding.
I'm not saying it is a legal finding, but
you said it was harassment. Harassment is a crime.
Hold on.
You can't harass somebody and it not be a crime.
Hold on.
It's either a crime or it's not.
Mr. Meyers, you got to slow down again. We're going to have a hearing on whether you're using the system to harass witnesses or victims.
That's ridiculous for you to even say that.
Again, you're threatening me.
By saying that's ridiculous, by my opinion,
it's disrespectful.
No, I want the hearing, but I'm saying the fact that this is the rabbit hole we're in right now is an embarrassment to the entire American legal system.
And if you think that my ruling,
People make rap
Hold-
videos
hold
from
on.
jail. They literally rap albums live on the jail phone. They literally talk into the jail phone and make music that's then published for monetary gain. Every day, people write books from the phone. People,
Mr. Myers,
no, I don't like you accusing me of harassment.
Hold on.
Flat out, because
Well,
you
hold
don't even
on.
know what harassment is.
Hold on, Mr. Myers. We're going to have a hearing next
To
Tuesday
determine what?
whether you're using this system to harass the victims.
You cannot use the word harass.
I
Because
can.
it's not a legal finding.
Again, you're threatening me
Oh,
again.
you're saying that I'm committing a crime.
I'm not.
You-
We're going around and around. I've already
So you're
discussed this.
saying you're gonna find if I'm
Hold
using
on.
the phone to
That's
harass
not
people.
enough time to prepare for that hearing. You need disclosure of the jail
I
policy.
need disclosure of the jail policy. We need more time.
Okay. No, I'm not. We're going to set this because they've asked for me to do this today. I'm giving you a hearing already. So I'm not going
Determine
to.
if I'm harassing them.
Yes.
And you're gonna make that determination?
Yes.
Are you a cop?
No.
Then how can you make a legal
All right.
conclusion?
You're being disrespectful again, Mr. Myers. You are.
Maybe you take
All
a
right,
second and
all right.
explain to me what
Pretty
you mean.
soon, you're hold on, Mr. Myers. You're getting to the point where you're being so abusive that I'm not going to let you represent yourself. You gotta calm down. You're going. No, we're done with this. So we're going to be back here at 1:30 on April 1st, and we'll make that
That was second.
April 1st.
It was the first.
the first. I'm sorry. Yeah, Tuesday.
So that's the.
I'm sorry. Hold on.
That's the first.
April 1st, Tuesday at 1:30. I apologize if I said the wrong date.
Why am I heard?
Okay, and then Mr. Parvin, you're going to bring the your phone in with those things
Yes,
recorded.
I'm
and
I'm
I'll-
going to talk to him, especially since I'm sure the jail can see in the order. He needs to see this. I want to use my iPhone. It's the
Yes.
big iPhone, has everything on there. It plays everything great. I want to show him that.
All
I
right.
do have a concern. Some of the disclosure, I mean, I could see any videos I know might have been live streamed, but some recent jail calls were disclosed. I was not able to download those files. But I'm assuming it's the
Okay.
same as what I already have. I don't know what that recent disclosure was.
So the recent jail calls go up until today's date. And so he's been getting the jail calls as we're getting them in.
Okay.
And then we're also disclosing the videos that go along with
Got
those
it.
jail calls.
Different, because I'm having a hard time downloading the jail call because you have separate recorders. That didn't play. All the videos played, but not the jail calls. But if it's the same, it's not an issue.
Well, and I'm happy to speak to Mr. Parvin to make sure that he has everything that we're going to be using at the hearing.
So we're gonna sit here for like 5 hours and listen to jail calls?
No.
Then we're not gonna get a true hearing and I'm not getting due process.
All right, you can
they
make
can
that
pick and
objection
choose.
then. Again, you're threatening me.
What?
Here's what's gonna happen. I'm not. It's a mixed case because I'm appointed on one but not the other case. So I'm guessing. Well, this could be a mutual. This is not for the second case, so I'm not appearing at the next hearing. That's what I'm wondering. For this hearing is just for this first case we're here today, not for. The one-
Your
Advisory.
advisory
Okay.
council.
But I could show him, I could get disclosure and still show him the media from my phone until
Right.
the jail can make arrangements to have him download it in the law library.
Right. So I'm going to order and have the minute entry reflect that Mr. Parvin is given authority to bring his phone into the jail to show the disclosure to Mr. Meyers. And in my release order, I'm also ordering the defendant to abide by all previous terms and conditions of release. All right. So we're going to be back here on Tuesday the 1st at 1:30. And Mr. Meyers, again, if I find that you're just being so abusive that you are unable to speak properly, I'm going to find that you can't represent yourself and have Mr. Parvin step in. And then if you continue to be disruptive, I can order you not in the courtroom. Your proceedings can occur without you here. I don't want to do that, but you got to behave yourself. Yes.
Would it be possible so that me and you can get on the same page for you to maybe give me a short list of do's and don'ts or something? Because, you know,
It's not that hard. You know,
I'm the common man. I'm not a legal, I don't speak legalese.
Mr. Meyers, I'll tell you, I have 300 cases at a time. I have sometimes 20 to 30 hearings in one day. Most people, even if they're charged with very heinous crimes, are able to behave themselves in the court. Well, they're able to behave themselves in the
If
courtroom.
you're innocent, it's different.
Some people are acquitted and some people are convicted.
Oh, innocent.
What I'm telling you is, Mr. Meyers, that most people are able to behave in the courtroom, and you're having a very hard time doing that. You're very argumentative and threatening.
I take offense to you keep calling threatening is a legal term again. Threatening you by saying what?
Okay, Mr. Meyers, I've given you my admonition. I can pull your right to represent yourself if you can't behave yourself.
But no, that's why I asked you if there was some
Right.
way that we can, like, maybe is there rules of court decorum or something I can read somewhere so that I can.
Mr. Meyers, I just told you, I have several hundred cases.
That's not me.
And I know, but everyone else is able to follow a normal.
Everybody else is innocent and is not innocent.
There, people are charged who are acquitted.
And I didn't say acquitted. I said
And everyone who's charged is presumed innocent until a jury finds them guilty or they plead. And so it's the case that the average person who is a defendant in a case or a witness or a lawyer or anybody can behave themselves in court, and you're having a very hard time. And if I make a finding that you're so abusive and obstructive, then I can pull your right to represent yourself, and I can exclude you from the courtroom if you cannot behave. So you need to keep that in mind.
it's hard to be innocent in an orange jumpsuit.
All right. We'll see everybody at 1:30 on.
So what about the modified conditions thing?
I just affirmed
So
previous release conditions.
So there's, you know how the modified.
I just told you that.
Motion, the amended, all that, we move past that now or what?
So you're held in $500 bond.
So we.
Affirming
modified
prior
the-
release conditions.
Right, okay. So the motion that they filed, the motion, then I responded, and then we were gonna come here and have today's hearing about, we've completed that portion?
Correct.
Okay, and it ends with me having a $500 bond?
Yes, and affirm current release conditions.
Okay.
All right.
That were previously,
Correct.
okay.
Tuesday, April 1st at 1:30 p.m.
To decide whether she's lying or I'm telling the truth.
There is no way he gets through all of this without at least one contempt charge. Thank you so much for watching, guys. Please like, comment, subscribe. Let me know what you would like to see, and I will catch you on the next one.